All righty, thank you, Elon. Let's dig deeper into the tech antitrust probe. Joining us now is Jack Nickus, a tech reporter for the New York Times, and Jessica Melugin, an associate director at the Competitive Enterprise Institute. Welcome to you both, and I'm glad you're here. Jessica, let me ask you, as you look at this, maybe from a cursory or 50,000-foot level, where do you or where do others perceive harm to consumers? Because that usually is the real reason that antitrust cases come.
Yeah, I think that's a really important question because we hear a lot of conversation about privacy concerns or data aggregation, sour grapes from some less successful competitors, or the size, the scale of these companies. But the U.S. standard for antitrust violations is consumer harm. And these congressional investigations and also the investigations at the DOJ, FTC, the state attorney generals, they're going to have a tougher time finding provable consumer harm as they look at these companies and how they've grown to be so successful. Because
a lot of the products that they sell, Jack, basically are given away for free. Jessica sounds a little skeptical that there is real demonstrable consumer harm. From what your reporting indicates, where might it lie?
Well, it's a good question. I mean, certainly the standard has been for consumers to be harmed, but there's a changing in the perception in Washington right now that maybe if they're harming competitors, that may be enough antitrust grounds for action. And we've seen, just this week we reported about how Apple was ranking its own apps well above other competitors' apps consistently in many common searches in the App Store. That's the sort of thing that could be harmful to competitors that regulators and Congress are obviously now taking a closer look at.
And they want to know why Apple would do that. I mean, could it be simply that the Apple apps are rated higher by the consumers who use them than the other apps? I don't know.
Well, in that case, I mean, Apple certainly had an explanation. They did say that their algorithm did that on its own. It was not intentional or underhanded by them. But what we saw today was Congress put out a very specific request to Apple, Amazon, Facebook, and Google for dozens of their top executives on dozens of issues to get specific correspondence to try to understand the thinking behind many of these decisions. And what Congressman Cicilline has said in an op-ed in the Times several months ago is they're looking for a smoking gun here. A lot of these cases have been built on correspondence in the past to see that there was intent behind some of these moves.
Jessica, when you have cases like this, what is the ripple effect or the unintended consequence from where you see it?
Yeah, I think that there is a real danger here. And just even casting about on these investigations, it can have a really chilling effect on such a dynamic industry. You know, the regulatory uncertainty now with which these tech companies and every tech company now has to wonder, well, what's out of bounds now? What's breaking the rules now? That doesn't do anything to spur the kind of innovation that us as consumers are looking for. And it also distracts from what these companies' real purpose is to keep making those products and services that we as consumers, we love them, we use them every day. And now they're going to be dragged into the bureaucratic mire in Washington, D.C., instead of doing what they're meant to be doing.
Jack, I also wonder, I mean, this sounds like it's starting as a request for emails and information. At what point does it turn into a demand for that?
Indeed. So this is, at this point, just a request for information. This is a typical congressional process. This could turn into subpoenas if the companies are not forthcoming with the information and Congress feels like they're not getting what they're asking for. What is important to note here is that this is a bipartisan request. If it is a single party, it is much easier for the companies to essentially dismiss it. But to have both parties in lockstep here means the companies really are paying attention.
But how do they, Jessica, how would Congress know if it's getting all the emails, for example, pertaining to Facebook's acquisition of Instagram? I mean, how does it know?
Well, I think that those kind of technical issues are probably well handled in the hands of committee staff and the attorneys for these companies. There's precedent for turning information over to Congress, so I don't think that part of this is controversial.
Quick final thought. Jack, do you have any idea how many billions of pages of documents we're talking about here?
I don't have an estimate. I think billions Potentially, we may be talking about that many. Certainly, this is an enormous undertaking, and I think it's a really good question is how does Congress know it's getting everything it wants?
Yeah.
We should know, however, the Justice Department is also looking at this, so law enforcement is involved.
All right, Jack Nicklaus, Jessica Melugin, thank you very much.
Thank you.
Thank you.